sufficient to create an issue of fact on his claims. And in addition, the court may not draw inferences from the evidence that defy logic and common sense. That's the Austin versus Shoney's case, 254 Virginia 134. So the issue here, Your Honor, is a couple-fold, and I'll take the statements, well, two of them in one category and one of them in the other category. But I think we're all clear that the sole issue here is whether Amber Heard can be held liable to Mr. Depp for defamation arising from the 2018 op-ed and the 2018 op-ed alone. And to establish that, Mr. Depp has to prove the following elements. He has to prove that the publication of the op-ed and that it was written by Ms. Heard. He has to prove that the statements in the op-ed were both false and defamatory. So falsity, and that they contained a sufficient defamatory sting, and he has to show that the statements were made with the requisite intent. In this case, actual malice on the part of Amber Heard. I'll save that argument till the end, Your Honor, and I'll focus on the first two at this point. And because it seems like plaintiff is proceeding under a theory of defamation by implication, under the Pendleton case, 290 Virginia 162, plaintiff bears the burden of proving that the statements at issue were designed and intended by Ms. Heard to imply a defamatory meaning. Designed and intended to imply a defamatory meaning. So, and to satisfy those first two elements, publication and falsity and defamation or defamatory nature of the statements, Mr. Depp bears the burden of proving that by a preponderance of the evidence. And to satisfy the requisite intent and show that Ms. Heard acted with actual malice, he has a heightened standard of proof that he must prove by clear and convincing evidence that Ms. Heard acted with that malice. So just want to talk about the two statements on domestic abuse in the op-ed. And Your Honor's well aware of the ample Virginia case law talking about how you have to view the op-ed as a whole, you have to view words in context. So these are the statements that read, then 2 years ago, I became a public figure representing domestic abuse. And then the other statement that says, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Now, those statements are entirely opinion, except for, according to Mr. Depp, the discussion of domestic abuse. So the statement, I became a public figure representing domestic abuse, and the statement in the second sentence that Mr. Depp was a man accused of abuse. The rest of those are inactionable opinion statements. Now, the evidence adduced thus far, Your Honor, shows that Mr. Depp can't sustain a claim on these for two reasons. First of all, the statements are true on their face. I don't think that there's any dispute about that, and that's been the subject of some testimony in this case. 2 years before she wrote the op-ed, Ms. Heard did, in fact, become a public figure representing domestic abuse when she obtained a domestic violence restraining order against Mr. Depp, and Mr. Depp was indeed accused of abuse. Those are facts that are true. Now, to the extent that Mr. Depp will argue that he's proceeding on a defamation by implication claim, again, the court should grant the motion to strike because the undisputed evidence is that he did, in fact, abuse Amber. Now, there's a dispute in this case. There's ample evidence that he physically abused Amber, but we acknowledge that there's a dispute in this case on that. But what there isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry have testified that abuse may come in many forms. It may be physical, certainly, but it may also be verbal, may be emotional, may be psychological. You'll recall,
Your Honor, if I may approach.
All right. Thank you.
Thank you, Your Honor. I've just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Heard's affirmative motion to strike, but I think we've anticipated the arguments made, such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard,
The arguments of counsel, and last night I reviewed all of the evidence that has been submitted in this matter. So as to the second and third alleged defamatory statements, at the motion to strike at this juncture, I view the evidence in the light most favorable to the plaintiff and reasonable inferences from the evidence to the plaintiff. And if there is a scintilla of evidence that a reasonable juror could weigh, then the matter survives a motion to strike. In this matter, there is evidence in the case that a jury could weigh that the statements were made by the defendant, that the statements were about the plaintiff, that the statement was published, that the statement is false, and the defendant made the statement knowing it to be false, or the defendant made it so recklessly as to amount to a willful disregard for the truth. The weight of that evidence is up to the fact finder. So the motion to strike is denied as to statement 2 and 3. The motion to strike as to statement 1, I'm going to take under advisement because if it's not a stipulation, I'm not sure what it is, but there seems to be an agreement that the tweet of Ms. Heard is part of the plaintiff's evidence, which is not in evidence at this point. So I can't rule on that statement whether or not it is just a tweet or if it's some sort of republication or something. I don't know because I haven't seen it yet. So as to the motion to strike on statement 1, I'm going to take an advisement because ruling on it now, it would be premature because I just don't have that evidence in the case, okay?
thank you very much, Your Honor.
All right.